When a security guard approaches you in a store and says, "Empty your pockets or show me what is in your bag," after accusing you of shoplifting, almost every person does the same thing. They comply. Because proving innocence feels urgent. Because refusing feels like what a guilty person would do. Because the accusation is so unexpected and the environment so public that the instinct to clear your name overrides every other thought in the moment. Here's what almost nobody knows. Emptying your pockets at the request of a private security employee is a voluntary search. It is not required, it is not compelled by law. And the moment you comply, you have consented to a search that the guard had no legal authority to demand in the first place. More importantly, an accusation without evidence does not meet the legal threshold that gives a private security employee any authority to detain you at all. The shopkeeper's privilege, which is the narrow legal doctrine that permits retailers to briefly hold a suspected shoplifter, requires something far more specific than a feeling, a hunch, or a general suspicion. It requires reasonable grounds, meaning specific, articulable facts connected to a specific person and a specific observed act of theft. An accusation without evidence is not reasonable grounds. It is an accusation. And responding to it by emptying your pockets transforms a moment where you held every legal advantage into one where you gave it away without being asked to. This video covers exactly what the shopkeeper's privilege requires before any detention becomes lawful. Why an empty pockets demand without proof is one you have the right to decline. What a false public accusation exposes the store to legally, and the exact words you say the moment security makes an accusation without showing you what they observed. Hit subscribe right now because this channel exists to give you knowledge that protects you in the moments where most people act from panic instead of understanding. Share this with one person before this video ends. Someone who would empty their pockets immediately because proving innocence felt more urgent than protecting their rights. Here is the reality most people are never taught. The shopkeeper's privilege is a legal doctrine recognized in most states that allows a retailer or their employee to briefly detain a person they have reasonable grounds to believe has shoplifted. The Restatement Second of Torts, which is a legal reference that describes how courts across the country handle civil liability, establishes the standard clearly. The privilege requires something close to probable cause specific to that individual. It requires a reasonable belief based on specific, articulable facts, meaning facts the employee can describe in detail, not a general impression or a fleeting observation. A guard who says, "I saw you take something," without being able to specify what they observed, exactly when, and exactly how, has not articulated the reasonable grounds the privilege requires. Without those reasonable grounds, the guard has no legal authority to compel you to stay, to search your belongings, or to demand you empty your pockets. Physically blocking your exit or forcing compliance after a baseless accusation can constitute false imprisonment, which is the unlawful restraint of a person against their will, a civil wrong that exposes the store to significant legal liability. A false public accusation of theft made in front of other customers or employees can also constitute defamation or slander, meaning a false spoken statement communicated to others that damages your reputation. Courts have found retailers liable for both false imprisonment and defamation arising from baseless shoplifting accusations where the store's employee could not demonstrate the reasonable grounds required. Here is what the bad way looks like. Security guard approaches a shopper near the exit and says, "I saw you take something and put it in your pocket." Shopper, shocked and wanting to clear their name, immediately empties their pockets. Nothing is found. The guard apologizes. The shopper leaves. The shopper feels they handled it well. They proved their innocence quickly. What they do not realize is that they voluntarily submitted to a search a private security employee had no legal authority to compel. If anything had been in those pockets, even something entirely unrelated to theft, The voluntary compliance would have made everything found usable in any proceeding that followed. The compliance felt like cooperation. Legally, it was consent. Here is what the good way looks like. Same guard, same accusation, same exit. Before a single hand moves toward a pocket, the shopper says this calmly and clearly. I have not stolen anything. You have not shown me any evidence of theft. I do not consent to a search of my pockets or my belongings. If you are detaining me, I want a police officer present immediately. Then the shopper stands still, hands visible at their sides, and waits. Those 4 sentences do everything that needs to be done in that moment. The first states clearly that no theft occurred. The second puts the burden of evidence back on the guard where it legally belongs. The third declines consent to a search, which means any search that proceeds from that point over the shopper's stated objection is legally compromised. The fourth invokes law enforcement, which immediately changes the dynamic, because a guard making a baseless accusation now has to answer to an officer rather than a compliant shopper. Drop a comment right now and tell me, have you or someone you know ever been falsely accused of shoplifting and emptied your pockets to prove innocence, not knowing you were not required to? Tell me yes or no. I want to know how many people have surrendered their legal advantage in that moment because nobody told them they had something to say first. Saying those 4 sentences protects you in the moment, but most people never find out what documentation created immediately after the encounter can mean if the store's accusation ever goes further. That is where the real protection gets built. If the guard calls police after you invoke the right to have an officer present, the situation moves into a different framework. A police officer who arrives and finds no evidence of theft has no basis to take action. You tell the officer clearly what happened. You were accused. You were not shown any evidence. You did not consent to a search. You requested police presence yourself. That account, delivered calmly and immediately, is the first statement in the official record. After the encounter ends, you do 3 things. First, you write down every detail immediately. The time, the location in the store, the guard's name or badge number if visible, exactly what the guard said, exactly what you said in response, and the names or descriptions of any witnesses who were nearby. Notes written at or immediately after the moment carry far more weight in any proceeding than accounts given days later. Second, if the accusation was made publicly in front of other customers or employees and it was false, you have a potential defamation claim. Attorneys who handle consumer civil rights cases treat these seriously because a public false accusation of theft damages reputation in a specific, documented way. The store's liability is real when the accusation lacked reasonable grounds and was made in front of witnesses. Third, you file a complaint with the store's corporate customer service the same day. You describe the incident in writing, request the name of the security employee, and state that you are preserving your rights regarding the false and unsubstantiated accusation. A written corporate complaint creates an official record and often triggers an internal review of whether the employee followed proper loss prevention protocols, which require documented reasonable grounds before any accusation or detention. Most people only understand how much legal advantage they gave away after the encounter is over. What it cost Gerald before he understood those 4 sentences makes that exact point. Gerald is 58 years old and was accused by a loss prevention officer at a home improvement store of concealing merchandise. He had placed an item in his jacket pocket temporarily while comparing it to another product on the shelf and had not yet reached the register. He was stopped at the exit. The guard accused him in front of several other shoppers and demanded he empty his pockets. Gerald complied immediately. The item was there. He explained what happened, paid for the item at the register, and was allowed to leave. He was embarrassed but assumed the matter was resolved. What Gerald did not know was that he had voluntarily submitted his belongings to a search driven by accusation and public pressure rather than legal authority. He also did not know that the public accusation, made in front of other customers based on an incomplete observation, gave him a potential defamation claim against the store. He walked away having surrendered both things without knowing either existed. Gerald now knows the 4 sentences. After this video, so do you. 2 legal foundations make everything in this video exact. The shopkeeper's privilege, as described in the Restatement Second of Torts, permits brief detention only when reasonable grounds specific to that individual exist. An accusation without specific articulable facts does not meet that standard. Detention or compelled search beyond that threshold can constitute false imprisonment, a civil wrong with direct liability consequences for the store. Defamation, and specifically slander, meaning a false spoken statement communicated to others that damages the subject's reputation, applies when a public accusation of shoplifting is made without any reasonable factual basis. Courts have awarded damages to plaintiffs in these cases, and retailers are aware of that exposure when a trained attorney raises it. Here is the complete recap. An accusation of shoplifting without evidence does not meet the reasonable grounds threshold required under the shopkeeper's privilege. You are not required to empty your pockets. You are not required to submit to a search. Complying voluntarily transforms a legally groundless demand into a consented search. The moment security accuses you without showing evidence, before your hands move toward your pockets, you say this: I have not stolen anything. You have not shown me any evidence of theft. I do not consent to a search of my pockets or my belongings. If you are detaining me, I want a police officer present immediately. Then you document everything immediately after the encounter ends. You file a corporate complaint the same day. If the accusation was made publicly without reasonable grounds, you consult an attorney about a defamation claim. If you have ever had security physically block your exit from a store, there is a video on this channel that covers exactly what to say to walk out legally, the false imprisonment standard that applies, and the exact words that put the store's liability on the record before you take a single step. Watch that one next. This video is general educational information only and is not legal advice for your specific situation. Know your rights, use them, stay safe.